Did you know that American women have the right to vote, but as of 2022 still have no legal guarantee of equal rights in the Constitution? In 2020, the nation and Iowa celebrated the 100-year anniversary of the 19th Amendment, which fixed into the Constitution the right of women to vote in elections nationwide. It was a hard-won victory, but American women were not done. They had voting rights, but still faced mountains of legal and social barriers to full equality with men. This video tells the story of the ongoing attempts to add the Equal Rights Amendment, or ERA, to the U.S. Constitution and prohibit all discrimination on the basis of sex. It's been 100 years since its introduction, and it's still not done. In 1923, a few years after the ratification of the 19th Amendment, Alice Paul, suffragist and leader of the National Woman's Party, turned her attention to an even broader push for equality, the Equal Rights Amendment. The amendment read simply, "Men and women shall have equal rights throughout the United States and every place subject to its jurisdiction." Some form of the ERA was introduced into every Congress for the next 49 years. Initially, support or opposition to the proposed amendment did not follow party lines. Groups with differences of opinion ended up on the same side, while groups that had previously worked together did not always agree on the potential impact of the ERA. Supporters of the ERA included Paul's National Woman's Party, middle-class professional women who wanted equality in their professions, and business owners who wanted to be rid of the costs of providing special benefits to their female workers. Opponents included many other reformers, including some feminists and women's labor union activists who had successfully lobbied for labor reforms to protect working-class women. They were joined by other social reformers and churches who sought to protect mothers and children or traditional families. By the 1940s, both the National Democratic and Republican Party platforms included support for the Equal Rights Amendment. Labor unions remained steadfastly opposed, and the amendment languished in Congress. Starting in the early 1960s, the second wave of American feminism, sparked by President Kennedy's Commission on the Status of Women, and the publication of Betty Friedan's feminist Mystique, successfully removed many legal forms of sex discrimination through legislation and court cases. The ERA, however, remained stalled until 1970, when Martha Griffiths, a first-term House member, took a stand against Emanuel Celler, powerful chair of the Judiciary Committee. Celler sided with labor unions to oppose the ERA, fearing it would eliminate protective legislation for women workers. Griffiths successfully employed a legislative tactic called the discharge petition to bring the ERA to the House floor for a successful vote. At this point, the text had changed a little since Alice Paul's days. It now read, "Equality of rights under the law shall not be denied or abridged by the United States or any state on the account of sex." In 1972, the ERA finally passed the full Congress and was sent to the states with a 7-year time limit for ratification. At least 3/4, or 38 states, are required for ratification. In the heady days of early 1972, states raced to ratify the ERA. Within 9 months, 21 of the 38 states needed had ratified. Another 9 ratified in 1973. Progress then slowed. In 1973, Phyllis Schlafly, a Republican activist, organized a national network of conservatives to oppose the ERA. Called Stop ERA, for Stop Taking Our Privileges, this group effectively lobbied against ratification in many states. By 1979, when the ERA's original time limit expired, only 35 states had ratified, and 5 of these states had rescinded their ratifications. Congress then extended the ratification deadline 3 years to 1982. During the 10 years of the ratification effort, both proponents and opponents of the ERA were diverse coalitions of organizations. Proponents included all the major women's organizations, political liberals generally, the League of Women Voters, and Catholic nuns organizations in defiance of their bishops. Public opinion was also in favor of the ERA during the 10 years of the ratification effort. It still is today. Leading the opposition was Phyllis Schlafly and her organizations, political conservatives, the John Birch Society, the Church of Jesus Christ of Latter-day Saints, the Catholic bishops, some evangelical churches, and a few retired military leaders. What was the nature of the debate? The ERA proponents wanted the constitutional guarantee of equal rights. This would make sex discrimination as important as racial discrimination in the eyes of the courts. Proponents also argued that the ERA would then eliminate the gender wage gap. In 1973, women's median pay was 56% of men's median wage. Opponents argued the ERA would undermine the traditional family, eliminate alimony and child custody laws, and lead to women being drafted, unisex restrooms, and gay marriage. They said the ERA would provide a constitutional protection for abortion, which had recently been legalized by Roe v. Wade. Other counter-arguments were legal ones. For example, they argued that the eventual ratification extension was illegal. They also said the ERA was not necessary because of the Equal Protection Clause in the 14th Amendment and due to state-level ERAs. After Congress's 3-year extension expired in 1982, both ERA supporters and opponents believed the federal ERA was dead. Feminists turned their attention to reforming sexual assault laws, criminalizing domestic violence, and passing state-level equal rights amendments. 26 states have equal rights amendments in their state constitutions. 8 of these, including Iowa, were enacted after 1980. Iowa's battle for a state-level ERA was hard-won as well. Amending the Iowa Constitution requires an amendment to pass in 2 consecutive legislative sessions and then to be ratified by voters in a popular referendum. The state ERA was put before Iowa voters twice, in 1980 and in 1992. It failed both times. In 1998, Iowa feminists tried again, proposing to add only the words "and women" into the state constitution section on individual rights. One of the state's ERA advocates, Minette Doderer, assured voters this was not an ERA. The third time the proposal passed by a wide margin. Meanwhile, in 1992, the 27th Amendment on congressional pay increases, first passed by Congress in 1789, was finally ratified after languishing for 2 centuries. This led to an article in the 1997 William and Mary Journal of Women and the Law that argued that the ERA time limit was a moot point, and the ERA could still be ratified. The 3-state strategy was born. Local activists began work to secure ratifications in just 3 more states. Nevada ratified in 2017, Illinois in 2018, and Virginia in 2020. The Trump administration Justice Department instructed the National Archivist not to accept the ERA ratifications, arguing the time limit had expired long ago. As of 2022, many of the arguments used by opponents are now moot points, since some results they feared have come about without the ERA. Proponents of the ERA are not done, however. The ERA would elevate sex discrimination to the same level of importance as racial discrimination. Based on recent Supreme Court cases, strict scrutiny would be applied to LGBTQ individuals as well. The ERA would reduce but not eliminate the gender pay gap and strengthen the legal basis for maternity leave and combating violence against women. The Equal Rights Amendment is currently in legal limbo. There are multiple independent efforts underway to move the ERA forward. First, there's a resolution in Congress to remove the time limit from the original ERA resolution. It has passed the House and is waiting for a Senate vote. Second, a legal case, Commonwealth of Virginia versus Ferriero, would require the National Archivist to accept the ERA and add it to the Constitution. The case is currently under appeal to the U.S. Circuit Court in Washington, D.C. Third, there's an effort to reintroduce the ERA into Congress and send it to the states again. This assumes that the states that ratified the ERA before would do so again. Fourth, there is an effort to lobby the Biden administration to rescind the Trump administration opinion, which would allow the National Archivist to add the ERA to the Constitution. Opponents today argue that the ERA is long dead and that its moment has passed. They also remain worried the ERA could provide constitutional protection of abortion. Do you have an opinion on the ERA? If so, contact your federal elected officials and let them know what you think. Consider joining an organization that is lobbying on the issue and stay informed. This century-long saga is not over.